We're considering contract formation. In the previous video, we looked at offer, acceptance, and consideration. That's the basic formula for contracts formation. And we saw that, although there are a few intricacies present, it's basically fairly straightforward. As you practice, no doubt you'll learn some more little details that maybe you don't know right now. Next, we consider substitutes for consideration and then defenses to formation. One of the more commonly tested ideas with regard to substitutes for consideration is the idea of a moral obligation. Well, they call it a moral obligation because it is something other than a legal obligation. A moral obligation does not serve as a substitute for real consideration. But you've got to look carefully at the facts. If we've got a situation where a person does something that develops a moral obligation as a result of a specific request, that's starting to look a little bit more like a bargained for exchange. But remember, a moral obligation by itself isn't enough to substitute for consideration and create a contract that wouldn't exist otherwise. Probably the most common substitute for consideration is detrimental reliance, and you'll see plenty of questions about detrimental reliance on the multi-state. You're also quite likely to see them on contracts essays all across the United States of America. This is one of the most commonly tested aspects of contract formation, where promissory estoppel creates a contract that wouldn't exist otherwise because of the absence of consideration. Here, in order to show detrimental reliance, the plaintiff, who is the person who has relied, just about always, has to show that the promisor should reasonably have expected reliance based on the facts of the situation, and that reliance would be of a definite or a substantial nature. In other words, the reliance has to be foreseeable, and the specifics of the reliance, not just the idea of reliance, but the specific acts of reliance done by the plaintiff would have to be foreseeable to the promisor at the time of the alleged statement. And of course, someone who's trying to show detrimental reliance has to actually prove reliance, not the mere fact that there was a setup for reliance. So, promissory estoppel is created when the promisor makes a statement that is foreseeable to induce some kind of detrimental reliance, and in fact does so. Now, the result of promissory estoppel typically is the creation of a contract. But let's pause for a moment. Suppose the contract is not created. What then? If we still have foreseeable detrimental reliance, but not enough to create a contract, the person who relied would still have a theory of liability that would result in a restitutionary remedy. There, we would look at the benefit conferred on the defendant and seek to avoid the unjust enrichment of that defendant. That's basically it. Now, turn to modification of contracts. This is not a complicated area, but I want to point out to your attention a distinction between the common law and the UCC. And this is a distinction that is extremely common on bar exams all over the country, particularly on the multi-state, but it's been present on many essays also. Contract modification. At common law, where we have a previously existing contract and the parties want to modify it, at common law, consideration had to pass in order for that modification to be valid. Now, under the UCC, consideration isn't required, but a writing is. And that's one of those little distinctions that you need to tuck into your mind and be able to call it up. This is one that is always triggered by the facts. They're not going to ask you directly whether or not a contract modification is valid absent a consideration or absent a writing. You've got to come up with the issue, spotting it by examining the facts. Now, where we have parties that have a valid contract with one another, and then they encounter problems, what then? Suppose those parties want to make some sort of compromise or a modification in order to resolve their dispute. And we assume for a moment that no fraud is taking place, that we've got two honest parties that have an honest disagreement. It is valid consideration on each side for each side to surrender their concerns under the prior contract, including their right to sue under a prior contract, in order to create a new deal. Now, we can consider that new deal to either be a modification of the previously existing agreement, or we consider it to be a novation, in other words, a brand new agreement that replaces the old agreement. In either case, the functional result is the same. We've got the same parties and a new agreement or a modified version of the old agreement, and they can proceed. The issue, is it consideration for a party to forego claims against the other party? Answer, yes it is. Now, a couple of other issues that relate to these substitutions for consideration, modification, and compromise and settlement issues. Suppose we've got a party who promises to make a gift to the other party. That's not a contract, that's a donative promise. What do we know about donative promises? They're freely revocable, unless there's foreseeable detrimental reliance. Where there is foreseeable detrimental reliance as a result of a promise to make a gift, the result is a binding contract. Estoppel will preclude the defendant from denying the existence of the contract, and he or she will be liable and will be compelled to perform. Now, suppose we've got a situation where a party makes a written promise to pay a debt that's older than the statute of limitations. Is that enforceable absent new consideration? Answer, yes. And this may be one area where, in truth, we've got a moral obligation serving as consideration, because a party signing a promise to pay a debt that's really unenforceable is not supported by any new consideration on the other side. Still, we've got a binding contract. And that's about all we need to consider with regard to these tertiary issues about formation. Now let's turn to defenses to formation. This is a significant part of the outline also, and you're guaranteed to see at least a couple of questions about this on the multi-state. You can also see it regularly on essay questions. The big defenses to formation include incapacity, illegality, fraud, and in particular the Statute of Frauds and mistake. There's one or two others. They are listed on the outline, and you may even encounter one or two more highly technical ones beyond the ones that are listed. But with regard to capacity, the big defenses to formation based on a lack of capacity include infancy, insanity, and duress and coercion. Now, let's think for a moment about infancy. This is a bright line rule. When someone is a child, contracts that he or she enters into are voidable. And one little detail that's pretty commonly tested is that the voidability of contracts entered into by minors actually extends beyond the point at which that minor reaches adulthood. How long? A reasonable time. You've got to look at the facts and make that judgment. And one other detail about the voidability of contracts entered into by minors is not only are they revocable at some reasonable point within the adult lifespan of that minor, but also they're revocable even if they've been fully performed on both sides. And those are details that are commonly tested enough that even in a capsule summary of the subject like this one, it's worth mentioning. With regard to insanity, obviously there are degrees of insanity. You can be a lot less screwed up to be incapable of entering a contract than you would need to be incapable of creating a valid will. To not have sound mind to create a will is a much lower standard than the degree of sanity that you need to create a contract. And then finally, duress and coercion. Now, I don't think it's very likely that you're going to see a question on any law school or bar exam in which the one party puts a gun to the other's head and says, sign this contract, and then later on we get asked whether or not it's valid. Obviously, that would not be a valid contract. But the more subtle area and the more difficult fact scenario is undue influence. Undue influence is considered a type of coercion, and it substitutes the will of the person who is influencing the signing party unduly. In other words, unreasonably, to the extent that the person doing the influencing is substituting his or her judgment for the person who actually executes the agreement. This is perhaps the most important area where the law of contracts touches the law of wills and trusts, because you are likely to see questions arising out of wills and trusts that involve contractual relationships with regard to the estate or with regard to parties within that estate. Undue influence can invalidate a will, and it also can invalidate a contract, and that's something to be aware of. Finally, with regard to incapacity, one fairly commonly tested scenario is where we have someone who has been incapacitated as a result of an accident or some medical emergency. Under those circumstances, there is an implied consent to medical treatment, including financial responsibility for the cost of that treatment. Now, let's turn to the rest of the laundry list of defenses to formation. Illegality is one such defense, not very commonly tested, but it's possible. Unconscionability is a defense that's more common on the essays than on the multi-state, but still it's worth being aware of the fact that a totally unreasonable contract isn't really enforceable either, and we will judge the unconscionability of a contract at the moment that it's formed. We're not going to look back at it from down the road and decide that subsequent events have rendered it unconscionable. Unconscionability is judged at the time the contract is signed. If the contract's not fair at that point, then we're not going to enforce it because we're going to claim it doesn't exist. Now, what about the situation where after the formation of the contract but before performance, circumstances change so drastically as to make the contract look as if it should not be enforced? Am I saying there's no defense present there? Certainly not. But it's a defense to breach. It is not a defense to the formation of the agreement. So unconscionability only is judged at the time the contract is signed. If the contract isn't unconscionable at that point, it never will be. It may still not be enforceable, but it won't be void or invalid as a result of unconscionability. Fraud is the point where the contract's outline touches the real property outline. Remember that in order to establish fraud, the defendant has got to deliberately communicate either aggressively or passively some material misstatement of fact. And when there has been a material misrepresentation as a part of a contract negotiation, there may be a contract theory of liability, but the plaintiff really wants a tort theory of liability arising out of fraud. And the reason the plaintiff wants that is because of remedies. The plaintiff can achieve a punitive damages award if he or she can show fraud, whereas otherwise, compensatory damages are all the plaintiff can get out of a contract theory of liability. And those contracts damages are complicated enough as it is. We'll have a look at them not too long from now. Next, material mistakes are a defense to the formation of the agreement as well. Where we've got a material mutual mistake, that's a complete defense to formation. Where we've got a unilateral mistake, that does not defend the formation of the agreement unless the non-mistaken party was aware of the fact that the other party had made a mistake. So, the quick bottom line, bilateral mistake equals no contract. Unilateral mistake only invalidates a contract if the non-mistaken party is aware of the mistake and trying to benefit from it. And that leads us to the Statute of Frauds. The Statute of Frauds is a very commonly tested area, and it is a defense to the formation of contracts. The more practice you do, the more you will learn about the Statute of Frauds. But there are a number of scenarios in the Statute of Frauds that are so commonly tested that even in a short video like this, I feel it's my responsibility to bring them to your attention. Where we've got a contract that is made in contemplation of marriage, that contract falls within the Statute of Frauds. So, the promise to convey Blackacre in return for marriage is not an enforceable promise unless the promisor puts it in writing. Also, remember, all contracts related to an interest in land are subject to the Statute of Frauds. But a contract that is a real estate brokerage account, is not a contract for real property. That's a contract for services. So that contract is not automatically under the Statute of Frauds the way it would be if it was a contract for any interest in land itself. Remember also, with regard to land sales contracts, the land sales contract has to include a price in order to satisfy the statute of frauds. Now, I say it has to include a price. If it includes the right formula for calculating the price, that's good enough to satisfy the statute of frauds. So we need the number, the actual dollar cost, or we need a clear enumeration of the formula for calculating the price. So imagine we've got a contract for the purchase and sale of a tract of land called, imaginatively enough, Blackacre. And suppose it's a generic tract of farmland and we know the boundaries, but we don't know how many acres it is. Is it possible for A and B to enter into a contract for the purchase and sale of Blackacre where the price listed is $40 per acre multiplied by however many acres our surveyor tells us there are? Is that valid? Answer yes, because it is a clear enough illustration of what the price will be to satisfy the statute of frauds. With regard to the 1 year aspect of the statute of frauds rule, the 1 year aspect, we calculate that 1 year running time at the date of the contract. That's the opening bell. The closing bell for calculating the 1 year period is the latest date for performance, not necessarily the scheduled performance. Again, as is so often the case, not only in contracts, but throughout the bar exam and the legal world, you've got to carefully read, and you've got to make these judgments based on what they give you. So knowing it isn't good enough. You've got to work with practical problems. Once again, I evangelize to you. Go forth and practice. One or two more details. First of all, remember that contracts for the sale of goods for $500 or more have got to be in writing to satisfy the statute of frauds. But generally, this does not apply to contracts that have already been delivered and accepted. If we've got an oral contract for the purchase and sale of goods worth more than $500 and the parties perform, well, we're not going to be able to rely on the statute of frauds to deny the existence of that agreement. Finally, also, remember, part performance takes a contract out of the statute of frauds. So often we'll have a situation where we do the analysis for formation, we go into defenses to formation, there's a clear statute of frauds issue, we explain it, but then we explain further by going right into the facts and saying what happened. Specific acts of performance, particularly when they're done by both parties, take the contract outside of the statute of frauds, and the contract will be found to be binding and valid on the parties. Well, that wraps up our complete consideration of contract formation. Next, we're going to turn our attention to figuring out what the terms of the contract actually are. We'll be considering contract interpretation issues in the next video.